Hello to everyone around the globe attending this very topical webinar. I'm Aleka Shepherd, the founder of LSLC, a maritime arbitrator, and the author of Modern Maritime Law and Risk Management. I welcome you to the first webinar of our 2021 Global Webinar Series and wish you a very happy and COVID-free year. 2020 was indeed tough and unpredictable. We were unprepared, so we naturally reacted to the COVID risks instead of managing them. So I hope that this webinar, which blends up-to-date legal and industry knowledge, will raise your awareness of COVID-related risks in shipping so that they can be properly managed in the future. You may have noticed, incidentally, that this is a distinguished panel of 4 ladies. It is the 3rd time we have achieved this in our seminars. It shows that women in our industry are recognized for their achievements in the law and shipping, and the LSLC supports talent, women professionals, and the young maritime professionals. We are indeed honored to have as chairman of this webinar, Mrs. Justice Cockerill. Dame Sarah has had a very distinguished career over the past 30 years at the bar. She was appointed at the High Court as a High Court judge in 2017 and judge in charge of the Commercial Court in August 2020. So over to you, Dame Sarah. The floor is yours.
Thank you very much, Aleka. Thank you so much for the warm welcome, and to the London Shipping Law Centre for organising this very timely event, and also to Essex Court Chambers for the technical support. Welcome to everybody. COVID, I think we all agreed, has had few joys, but most definitely one has been the possibility for events such as this to reach a greater audience than seminars generally would. And I know from talking to Gerard that we have attendees from around the world, and that there are people who register who maybe can't make it at this time, but will pick this up later. So welcome to everybody. I'll start with a little bit of basic housekeeping. As you will probably be aware, the session is being recorded. There will be a Q&A at the end. Please put your questions in the Q&A section, which you'll find at the bottom of the screen. You can also add a suggestion as to whom your question might first be directed, if you think that would be helpful. We'll then sort them out and ask them at the end. You should also be aware we will not be outing questioners by name. So if you are, for example, in 2 places at once, or you want to ask a particularly difficult question and you don't want to get any comeback from any of the panel, no one will ever know it was you. We are aiming to run to 1 hour and 15 minutes. That's going to be roughly 20 minutes per section, and then time for questions. Turning then to the topic for the evening, let me start on a lighter note. I should give those of you who are in the country a quick warning about the topic of this evening's presentation. I was warned by the Court of Appeal this afternoon that we should be aware that charter parties are illegal under the Coronavirus Act, as all parties are illegal. But aside from the joking, one of the things that we all love about practicing in the shipping world is its international nature. That's something we have taken for granted over the years. But throughout, one of the things we have learnt to expect is to expect the unexpected, and to be ready for the strangest of circumstances, to be tested very thoroughly and with rigour against concepts and the standard form wordings which one might say form the backdrop of our world. Even on that basis, I suspect that if we had tried, we could hardly have done better in terms of inventing a single cause in coming up with something which had the capacity to engage more arguments. Obviously, at the moment, we are still in the middle of coronavirus. From my perspective, we've seen very little come to court. we are somewhere off seeing the arguments played out in any great numbers and with the finesse that will doubtless come along in due course. But across the different segments of the business, we know that different pots are coming to the boil. We all know about the crew issues, at least at headline level, but there's obviously huge potential for issues on insolvency, on force majeure, crew change issues, relevant clauses about contagious disease and specific coronavirus clauses, and much, much more. And this evening, we have 3 experts to give us progress reports from those different viewpoints within the business, and probably some very important warnings as to what is to come. Our first panelist is Philippa Hopkins QC. I'm going to try and keep this neutral since I've known Philippa for nearly 30 years. And if I speak out of turn, she'll be bound to tell you where the bodies are buried. Philippa joined Essex Court Chambers almost before she left university, it seemed, helping John Thomas with his work over her summer holidays. Since then, she has enjoyed, or I think mostly enjoyed, I'd be prepared to say there have been a few grumpy days, a brilliant career. And although she has of late spent a lot of time on high-profile things like Bank Mellet and suggesting that Lord Legate might not be right about relational contracts, her practice has always had shipping at its very heart. Beth is now a partner at Hill Dickinson with lots of interesting experience in the shipping, shipbuilding, commodities and marine insurance sectors. She has been involved in a number of high-profile cases, including the Titan Glory saga, and has vast experience with blue-chip Asian and multinational companies, particularly perhaps in the Southeast and South Korean market. And she is also, as I think we can all see, or we will be able to see, a keen student of avant-garde art. Kieran, now at the ICS, is the Principal Legal Director and Secretary of the Maritime Law Committee and the Insurance Committee. So I remember distinctly when she was in practice and when she moved in-house to a P&I club. Nowadays, she's responsible for the ICS legal team and advising member associations on legal, insurance and competition-related matters affecting ship owners. Her team, of course, also represents the ICS on all legal and insurance issues at the IMO and at the other UN agencies and the UN itself. So she had plenty on her plate, even before COVID came along, with issues, for example, of biodiversity, I think was big in her world. But of course, current circumstances have created what one might call a perfect storm for her. I believe, however, that she treasures an ambition to run a vineyard, and heaven knows that COVID has driven us all to drink. So that seems like a good plan when she gets a bit of time to spare from this perfect storm. But for the moment, I dare say it's on the back burner. So with that introduction, I'll hand over to our team of experts to guide us through the issues which lie before us. Thank you.
Sarah, thank you. So I am going to go first. I'm going to try first to share my screen. This is usually the point at which things go horribly wrong, though perhaps not, except I'm in the wrong place. There. I'm sure somebody will tell me if I am failing to share my screen, but I think and hope that I have done it. So here we are, 1 year on from the outbreak of the pandemic and into a new year. And I think that for most of us, if 2021 is going to redeem or at least improve on its predecessor, it's got some work to do, but there we are. That being the case, we thought that now would be a good opportunity to take stock and to have a look at the impact that COVID has had and is having on the shipping world, and specifically on charter parties and on relationships connected with charter parties. We're going to be looking at this evening from a number of different angles. First, what's happening in the courts. Secondly, what's happening in terms of the day-to-day advice being given by dispute resolution lawyers. And thirdly, what is actually happening at sea, particularly as concerns seafarers, who, as they are pointing out on my slide here, are very much the COVID frontliners. They stay on board, sometimes I fear for rather longer than they want to, so that we stay at home. So we thought it would be a good idea to start with a bit of a retrospective, going back 9 or 10 months when the pandemic first hit us in the UK. A lot of lawyers, myself included, I'm afraid to say, put pen to paper, or perhaps more accurately, finger to keyboard, all of us speculating on the legal issues that we expected to crop up in the charter party context. There are lots and lots of pieces still out there on the web that you can read, and they identified very much the same sorts of things. So force majeure and frustration arguments were high on the list. And you may recall that back in the early months of 2020, a number of Chinese companies in particular were producing what were described as force majeure certificates and were meant to prove that a force majeure event had occurred. Then people were debating whether safe port issues might arise. Might COVID render a port unsafe, for example? There were discussions around quarantine and the impact of that. What about free pratique? Would it cease to be a mere formality and become something more? And what about delays, detention, demurrage, off-hire arguments, all those anticipated? There was discussion about deviation, particularly in the context of ports being closed. So that was then. What has happened 9-10 months on? Well, of course, in terms of what has happened, it depends on where you look and what angle you look from, and Sarah has already alluded to that. What's happening in the courts? The answer is, as Sarah's already said, not a lot yet. And that's for the fairly obvious reason that most issues take a good while to filter through. And of course, most charter parties contain arbitration clauses anyway, so they're not usually going to get to court until after an arbitration has concluded, and then only on a Section 67, 68, 69 Arbitration Act application. So those are going to take some time. They will come, but we're a long way off seeing them yet. My perception generally from a review of the law reports and on the basis of my own experience was that the commercial court wasn't seeing a lot of COVID-related shipping issues yet. Insurance, of course, is quite another matter, as many of us know. And I asked the judge in charge of the commercial court, who is, of course, our chair for tonight, whether that was her perception. And she said, yes, that is the court's perception. What is being seen is a set of disputes that arise because of COVID and that do have to do with charter parties, but where the impact of COVID is less direct. And those were perhaps the sorts of things we didn't think so much about 9-10 months ago. Looking back, we can see exactly how they've arisen, but they were not perhaps uppermost in anyone's minds. What sorts of issues? Well, alas, insolvency, almost inevitably. The courts are seeing insolvencies that are related either directly or indirectly to COVID, in particular because of the fall in oil prices in 2020 and the fall in freight rates in the earlier part of 2020. For those of us with longish memories, it almost feels like the 1990s all over again. An example of that is the deep ocean restructuring, which is directly to do with vessels being idle as a result of COVID. Then there's the cruise industry, which many of you will know has been very badly hit indeed. In the courts, the sale of a number of cruise vessels is being dealt with by the Admiralty Court now. And many of you will know that cruise maritime voyages went into administration in May last year. Some of their vessels have been sold by the court. And there's an interesting set of cases on the go now, including some charter-related issues, because some of those vessels were on bareboat charter. In fact, in the context of that litigation, there was a judgment of the Admiralty Registrar only yesterday on an issue relating to port charges. There will be more, so watch this space for developments on that later in the year. There's also been a series of decisions relating to letters of indemnity given under charters, mainly in the tanker trade, a series of decisions relating to orders for enforcement, most recently the Tenacity Marine and NOC second judgment. Those cases are all being dealt with by Judge Pelling, who has taken a robust approach. They concern applications for orders to make payment or to put up security under letters of indemnity, where those LOIs have been produced in exchange for delivery without bills of lading. And a number of givers of letters of indemnity, charterers, have said, well, we can't put up security to release your vessel because we haven't got any money, because we're going bust because of COVID's impact on the oil price. Not, you would have thought, a desperately attractive argument, and certainly the court's approach in general has been to order compliance, although in the Tenacity case, Judge Pelling was persuaded that the defendant had showed that it really, really could not pay, and unusually discharged an order on the ground of impossibility of compliance. I also understand that there have been a number of anti-suit injunction applications, proceedings being commenced in breach of charter party arbitration clauses abroad, typically in China. As many of you will know, applications of that kind must normally be brought promptly, but applicants have delayed and they have cited COVID-related reasons for the delays, such as we couldn't get a surveyor at the port because of COVID, we couldn't get Chinese law advice because of COVID, and so on. So that's, if you like, an indirect COVID impact. In terms of other lawmaking, legislation, what's been going on, there's not a lot that is new that will impact on charter parties. And of course, it's only likely to be relevant where you are dealing with vessels calling at UK ports. But nonetheless, one should be aware of it. There's not a lot in the Coronavirus Act itself. The UK government guidance on responsible contractual behaviour is worth looking at, if only because it is rather extraordinary. I have never seen anything quite like it before. It is essentially an exhortation of a non-binding kind by our government to contracting parties to be nice. Whether anyone will take any notice of it remains to be seen. The Corporate Insolvency and Governance Act 2020, SIGA 2020, is interesting. And the new section 233B of the Insolvency Act, which it incorporates or rather enacts, potentially does have some impact on shipping and chartering. It stops suppliers terminating or varying a contract for the supply of goods or services on the grounds that the buyer has gone into an insolvency proceeding, typically administration. And it seems to me that that could well be relevant in the context of supplies of bunkers and necessaries. It's a funny section. It seems to me that there are considerable drafting infelicities and there are lots of arguments to be had around its operation. And indeed, I've already had one of those arguments in front of the Admiralty Registrar in the litigation I mentioned just now, but fun and games to be had with that one down the line. But all in all, if you were sitting in the comfort of your barrister's chambers, or more accurately, your home office at the moment, and just reading the reports, you would be forgiven for thinking that COVID had had very little impact on the working of charter parties at all. And of course, nothing could be further from the truth, as any current shipping solicitor will tell you. What then is being seen at grassroots level? It's quite interesting to think about what's not being seen. And my perception is that there isn't a lot in terms of the force majeure and frustration arguments that we all talked about so eagerly at the outset. And really, the idea that there could be any port without COVID, such that a port with COVID is unsafe, now seems rather quaint. My perception, and others will no doubt have their own views, is that the two big areas where we are seeing trouble and disputes are firstly delays and secondly crew-related issues. And one striking aspect here is the extent to which parties are trying to rely on or trying to incorporate specific clauses in their charter parties to deal with some of those issues. I've referred to the first of those on the slide you see in front of you now, and that's the BIMCO infectious or contagious diseases clauses, separate versions for time and charter parties. Those time and voyage charter parties. Those are not, of course, specifically COVID related. They were developed some years ago. There are issues as to whether they actually do the job that the parties want them to do in the context of COVID. When I say the parties, of course, owners and charterers don't necessarily have the same view as to what the right job is. They come at it from very different standpoints. But there's a question as to whether this clause is fit for the current purpose and whether it does what parties want and does it in the right way. As I say, it wasn't developed for where we are now. We'll come on to what might happen in that regard. Intertanko brought in a specific COVID clause very early in the pandemic. Again, versions of this for time and voyage charters. It puts the risk of COVID-related delays squarely on charterers. I don't have a sense as to how often that is being used. Beth and Kieran may, and I know Kieran is going to be saying something about the use of clauses to deal with issues of this kind presently. There is also a new BIMCO clause dealing with crew changes. As you're going to be hearing shortly, effecting crew change has been a huge issue since all this started, and it's an issue that is not going away, and not going away anytime soon, because of port closures, because of quarantine regimes. As a result, on the initiative of the ICS, last year, June last year, BIMCO developed a specific crew change clause for time charters. It affords an express liberty to deviate for a crew change, and there are then two alternatives. The vessel can remain on hire, but at a reduced rate to be agreed, or it can go off hire. Obviously, as to where the parties will end up on that is going to depend on relative bargaining power, I suspect. So there you have two clauses that are a specific industry response to critical issues. And as we'll see at the moment, there's more on the way. So that is what's on the ground now, at least from my standpoint. Going forward, what can we expect to see in the next few months? I would highlight four particular issues. The first is, I think we will see more and more indirect COVID-related disputes, disputes resulting from insolvencies, disputes resulting from the early in the year drop in oil price, drop in freight rates, drop in tonnage values, and then disputes resulting from the more recent rise in some sectors, particularly container freight rates. We all, those of us who are lawyers, all know that it's rates going up and down that give rise to busy times for lawyers. A flat market is a dull market so far as lawyers are concerned. It's the ups and downs that always give rise to parties wanting to stay in their contracts, get out of their contracts, depending on where they are sitting. I am seeing a good deal of that at the moment in my practice. I'm sure others are, and those disputes are going to come to arbitration, they're going to come to court. Secondly, I am informed by those who instruct me that the various demurrage and detention claims, delay-related claims, are now starting to work their way up the legal food chain. They're with solicitors now, there's more coming. I am certainly starting to see them. I know others in my chambers are. So issues around quarantine, laycan, long delays, difficulties with delivering vessels into charter, redelivering vessels under charters. We will see a lot of that. And I suspect that for many of us, that is going to be a pretty consistent diet for the weeks and months to come. Thirdly, I think given the unusual circumstances in which we all find ourselves, there is going to be a rise in attempts by parties to deal more expressly with COVID issues in their charters. I understand that BIMCO is presently trying to revise the infectious or contagious diseases clauses for time and voyage charters, the ones I mentioned earlier. I'm very grateful to Nicola Cox at the West of England for information about this. I think she's on this seminar. And she tells me that the aim of the revisions is to widen the ambit of the current clause so that it covers not just diseases, which is a defined term in the current clauses, and epidemics, but also pandemics like COVID. And the intention is that it will include provisions that address the particular issues that have arisen. Crew changes and bunkering are the ones she mentioned in particular. I would have loved to be able to show you a draft or tell you about a draft, but I understand there is not a draft in circulation yet. And perhaps unsurprisingly, there are differing views within the industry as to where responsibilities should lie. That is something which is coming up again and again. One of the big problems is that charterers think that owners should pay for time lost dealing with COVID issues. And of course, owners think differently. And that, I suspect, is going to be a continuing tussle. So even if and when we get further standard clauses, query whether parties are going to use them, query whether parties are going to come up with their own clauses, query whether parties' own clauses will be good clauses, whether they will be fair clauses and clauses that work. It remains to be seen. And then the fourth issue for the future, when I was researching material and speaking to people in preparing tonight's seminar, the overwhelming message was clear. The biggest issues which are being seen on the ground are crew related. And you will hear from Beth about this, and you will hear from Kieran about this. And those are issues which long term are going to feed into legal disputes as well. And they're going to be what the courts and the tribunals see. Crew is undoubtedly where it is at. And not only do crew issues give rise to legal problems that are of interest to lawyers, as you will hear, they are giving rise to very, very serious human and humanitarian issues, and the sorts of difficulties with which our industry has not actually had to grapple before. And so on that note, I'm going to leave you with a picture of 3 of the crew's maritime vessels languishing at the port of Tilbury on extended lay-by. I don't know whether at the point when this picture was taken, the crew were on board unpaid and having to seek humanitarian relief, but that is what happened. So that, I think, leads reasonably neatly into the next presentation, which is Beth. I'm just going to stop sharing, and I hope that she will then be able to take over.
Thank you, Philippa. Let's get my screen up. Hopefully that has appeared successfully. Thanks very much, Philippa. I am not going to quite pick up from the plight of the crew in Tilbury. I'm going to start actually with the various issues that may arise, particularly in relation to the notice of readiness arising out of free pratique. Now, COVID is an illness which affects people. Crew are people, and the health clearance of the crew is a necessary thing to underpin a valid notice of readiness being given. Now, taking a step back, notices of readiness are very important documents, and they're very important to get right, particularly for an owner. They govern the commencement of time and the passage of risk from the owner to the voyage charterer for the time spent in port, either loading or discharging cargo. They may also impact, depending on the charter in terms, on rights of cancellation, and I'll illustrate this in context in a couple of slides' time. Classically, the notice of readiness is a statement that the vessel is an arrived vessel, so she's in the correct place, and that the vessel is ready in all respects to load or discharge the cargo. Readiness itself encompasses both physical readiness to receive or discharge the cargo, but it also covers documentary readiness. Now, I think it's probably fair to say that many elements of the notice of readiness and the ability to give a valid one has each taken its turn in the sun, and documentary readiness itself has not been a huge focus of any of the decisions that are kind of widely cited when you have a notice of readiness issue, but this may be its time. Particularly given the requirements for free pratique. Now, free pratique is one of the documents, one of the parts that make up documentary readiness. And I'll explain or give the definition of free pratique from the Eagle Valencia, where the court set it out quite neatly for us. Free pratique is defined as being official permission from the port health authorities that a ship is without infectious disease or plague, and the crew is permitted to make physical contact with shore. So we take that as our starting point, and it should be obvious just from the quote itself that it's very, very relevant to COVID, albeit made some 10 years previously. Now, documentary readiness, there's always been a kind of gloss applied to the approach or the strictness of the requirement for a vessel to have their documents in order before giving a valid notice of readiness, and that gloss really, I suppose, recognises that in many ports it is not possible for a vessel which is otherwise ready to get all the documents in order which are necessary before being shortly on or having just berthed. So the gloss which has been applied is the principle of mere formality. So if the master has no reason to believe that they won't achieve documentary readiness when the port authority is able to give them the go-ahead, whether that's customs clearance or free pratique, then a valid notice of readiness may be tendered. which gives rise to one question, which is whether free pratique can be considered a mere formality in the context of a global pandemic. It's not really been decided yet, as you might imagine, but we do have some hints and tips from a couple of oldish arbitration reports. The first is London Arbitration 1205, which considered whether free pratique could be a mere formality in the context of SARS, which I think in around 2005, many shipping litigators, including myself, were getting a little bit jumpy about whether SARS was going to take off and become the next big thing that was going to cause issues for lay time and demurrage claims. Fortunately, it didn't. But in arbitration 1205, the vessel had arrived into a European port, having previously called in Algeria, and the master gave notice of readiness and relied on a mere formality in terms of free pratique. And the arbitrator there, and it's buried about 3/4 of the way down the report, discussed this in about 2 sentences. And said, in the context of SARS or other flu-like epidemics, a master cannot consider free pratique to be a mere formality, particularly when having previously called it a developing in a developing country, and can sensibly expect that free pratique formalities would be more closely scrutinised by the next port, in that context, a port in Europe. So, assuming that the same panel or all arbitrators from that panel consider the question in the concept of Covid-19 or in the context of Covid-19, there is a bit of a steer there as to whether mere formality works in practice for the obtaining of free pratique. The other arbitration award, which is 1100, came at it from a slightly different point of view, where there the master and 3 members of the crew didn't have valid vaccination certificates. But the argument run by the owners there was that there was no reason to believe that once they were able to be vaccinated and obtain their vaccination certificates, that there would be a problem. The arbitrators in that case dismissed that argument, saying free pratique could not possibly be considered a mere formality when you don't have the relevant certificates. So we have 2 arbitration decisions which look at free pratique and particularly the arbitration decision 1205 in the context of an epidemic. So I'm going to dig into the idea of mere formality a little bit more, because it seems to me that for mere formality to work as a guiding principle, that there's always been an underpinning in terms of the master's knowledge when tendering the notice of readiness. And in the Lenados, it was said that the master there was an implied duty of good faith or requirement of good faith on the master to reasonably look at the facts or the context in which they were tendering the notice of readiness. And that was roundly kind of rammed home in the J. Ganesh, where the court found that if the master knows that the vessel is not in the condition which would entitle free pratique to be a mere formality, the master cannot give that notice. So where does that leave us or a master today in terms of giving a notice of readiness before free pratique has been formally granted by the port that they're tendering notice for? I don't suppose the answer is a straightforward no, you cannot rely on free pratique being obtained as being a mere formality. It seems to me that there's a continuum in terms of a situation where it would be a mere formality and a notice of readiness is perfectly capable of being given validly, and then at the other end where all the facts suggest that there is no chance at all that a notice of readiness can be considered valid. And I'll give you a couple of examples of how that line perhaps moves. So we start off with the master having no reason to believe that free pratique is anything other than a mere formality. Suppose he's been together with his crew on board for at least 14 days and nobody else has attended the vessel, and that nobody's displaying any symptoms. In that context, arguably a notice of readiness would be, or the obtaining of free pratique would be a mere formality. and it's perfectly possible that a valid notice of readiness could be given before the port health authorities have signed off on it. Take that set of facts and move it on a bit. Say a new crew has joined the ship, it's been less than 14 days, and perhaps a pilot has boarded in the intervening time. Does the position change? Will the master have to wait a bit longer or obtain official port health clearance before a notice of readiness is capable of being given? What then happens, or if in a situation where somebody on board is exhibiting some of the symptoms that are related to COVID-19, but also many of the symptoms cross over to more usual and less threatening illnesses such as a common cold or flu. So somebody's exhibiting symptoms, the master advises the port health authorities who say, well, you know, it doesn't sound great, but it also doesn't sound bad. Perhaps the crew member should isolate, and they give directions for the isolation of the crew member, but the vessel itself isn't placed into quarantine. There, I think we start to get into an area where it becomes more difficult to see that a master can validly tender a notice of readiness on the basis that the obtaining of free pratique is no more than a mere formality. And then we get into the area where it's absolutely well, very difficult, I would have thought, to maintain a mere formality over free pratique, is where a member of the crew has symptoms, there is a test, and that test is positive for COVID-19, and the vessel is put into quarantine. I would say at that point, without any doubt, that any notice of readiness is likely to be wide open to a challenge. So the sliding scale of the master's knowledge and how the factual context could change a valid notice of readiness to one which is not. There's another aspect, I think, to the master's or the factual context in which a notice of readiness is given, is the question of whether a COVID test is considered a routine matter. My understanding is that some ports are requiring that all crew, for each new arriving vessel, everybody has to be tested before further directions as to taking place in anchorage or berthing are given. And it arises in the context of the decisions in the Tres Flores and the Delian Spirit, where various arguments were made about whether the steps that were taken in those cases were a routine matter or not. In the Tres Flores, a fumigation wasn't a routine thing that the port there was imposing. It was imposed, or was required of the vessel, because there had been a hold inspection and the hold was found to be infested. And then in the Delian Spirit, Lord Dennin opined that where there was a known disease, so here COVID, I suppose, that having been tested and found a positive result, which would prevent free pratique, would put it beyond doubt that the vessel itself was not ready to load or discharge. And so the question of whether routine testing alters the ability to be able to say that the obtaining of free pratique is a mere formality or not, it seems to me potentially interesting. I think where you have potentially a port which requires everybody to be tested, you know, before the vessel is allowed to berth, then it could be argued that it's a routine matter. And if the master has no reason to suspect that the crew is ill at all, then it would, I think, be arguable that the obtaining of free pratique is a mere formality. Conversely, if the COVID test is in response to a report of symptoms being reported by a member of the crew, then it becomes very much not a routine matter, and it falls straight into the Delian Spirit and the Tres Flores category of it being a step, and the follow-on quarantining being a step that must be taken before the vessel can be considered ready to load or discharge, and therefore able to give a notice of readiness. Okay. So why does it matter? This is all terribly interesting, but is any of this coming through? And unfortunately, yes, it is. If this is really an illustration of how some of these issues are beginning to develop. So we have a notice of readiness tendered in reliance on a whether in free pratique or not clause. The vessel goes into a port which routinely requires testing of all to take place on all vessels, and the first test confirms that there is a crew member with COVID on board. That probably is going to invalidate the notice of readiness, irrespective of the whether a free pratique or not clause, although there is a debate still to be had about whether that is correct or not. So that would be difficult enough or bad enough in terms of the passage of risk and the validity of the notice of readiness which had been tendered. But it potentially becomes more of an issue where the cancellation rights in the voyage charter are tied into the validity of the notice of readiness being given. So imagine a situation where the member of the crew is tested positive for COVID, the vessel is placed under quarantine, and the effect of that is that the vessel is unable, the master is unable to give a valid notice of readiness until after the quarantine period has expired, which itself is after the cancellation date has passed. It's a fairly or potentially a very fine decision to be made there by the voyage charterers about whether they cancel or not, and what happens next. I think it's probably right that any quarantine imposed following a positive COVID test is likely to be time which is going to be at owner's risk, and I think that would be difficult to argue against. But in this kind of doomsday kind of scenario in terms of the laytime demurrage and cancellation provisions in a voyage charter, what then happens if a next test comes clean and there's no evidence of COVID at all on board? Has that cancellation right, if it has been triggered, become a repudiation of the voyage charter? And how much expert evidence are we likely to need to have on this point? Now, along with everybody else, we've all, to a certain extent, become expert epidemiologists over the last 10 months. But the science around the reliability of tests is something which I suspect is going to become more of an expert issue, where there are, particularly here or in this kind of case study or example, where a cancellation has taken place, but the evidence perhaps doesn't entirely stack up to underpin either the decision to place the vessel into quarantine to begin with, or the decision to trigger the cancellation right. So the point there, I suppose, is that that there are difficult questions still to be answered, and will start to be answered as we kind of go through the next 12 months or so, as these issues filter through to the lawyers and eventually to arbitration or to the courts. Okay, in a bit of a gear change, I'm going to briefly touch on provisions relating to crew changes. Kieran next is going to bring this all very much to life for us on the, and it's terribly easy to get bedded down into the contractual rights and forget that at heart this is all about people and a very worrying situation that they are finding themselves in. Crew changes are particularly difficult at the moment, and the common charter parties in use are not particularly great in terms of allocating the risk of time or delay that arise in relation to changing the crew, particularly in the present circumstances. I'll touch first on the obligation of seaworthiness. There are express and implied obligations in charter parties and related to seaworthiness, and seaworthiness, I think, does cover the well-being of the crew. Whether it's an absolute obligation or whether there's just a due diligence obligation that exists on delivery or throughout the charter party will very much depend on the precise words of the charter party in question. But there is, I think, an obligation to ensure that crew are regularly changed and to make sure that they are changed in good time in relation to their contracts, quite distinct to what we're seeing and have seen over the last 10 months, where some people, large numbers of crew, have been kept on board for far longer than they should have been, and that is a big risk to the seaworthiness of the crew, let alone their own the crew's well-being itself. So there's an obligation there. Again, as I said, the charter parties commonly in use are not fantastic for dealing, or they don't have the tools really in them to enable the owners and the charterers to easily divide up between themselves what's to happen when a crew change is required. But as distinct from previous times, it's just not a matter of routine any longer. There's very few contractual hooks available to permit an owner to deviate in order to change crew. There is the limited right to do that where it is to save life or property, which is extended under the Hague or Hague-Visby rules to include any reasonable deviation, although there could be a question about what is or what is not a reasonable deviation. There is possibly a common law right to deviate to change the crew that exists independently of whatever the charter party might say, and that arises in Kish and Taylor. But there, I think you would have to show that the deviation was necessary to enable the vessel to operate safely, which is quite a high bar or to try and clear. The other aspect, so being able to change crew is one thing, but the charter parties presently do not really cater for what happens when the crew has changed, and there needs to be a quarantine period for the new on signing of crew. Sticking my finger in the air, I would say it's more likely or not that the quarantine time is going to be at owner's risk. And so under a time charter, the vessel could be placed off hire, particularly if there is a whatsoever amendment in the NYP clause 15. And also in the Doric Pride, Lord Justice Ricks suggested that as the owner was generally responsible for the crew, delays relating to crew issues would be at the owner's risk. What the position truly is could, I think, change depending on the question of routineness of the quarantine. Is the quarantine routinely imposed because there's been a change of crew? That would probably, I think, be at owner's risk of time, and they should bear that time. Or has the quarantine been imposed because the port authorities are concerned about the previous port which has been called at? And there, I think there would be an argument that that time, the quarantine period, may be at charterer's time because it was the charterers who organised the rotation for the vessel.
So we've had a question about no crew change clauses. Do you agree that no contractual clause, however skillfully drafted, can limit or remove a master's right and duty to take necessary measures if he considers that the health of his crew and or the seaworthiness of his vessel is being placed in serious jeopardy? It's obvious that no one would seriously dispute the master's right to land and replace a member of crew who has suffered serious physical injury. Should it be any different if a crew member is suffering extreme mental and physical exhaustion as a result of remaining on board well beyond the expiration of his employment contract? So that's quite a meaty and complex question. I don't know, it came in on your watch, Beth. Do you want to take it first, or if not, Philippa might be prepared to go first.
Well, I have a stab at it, but I think I do agree that no matter how skillfully drafted any clause, let alone no crew change clause, they're rarely impregnable to challenge. And I think I do agree that it probably couldn't remove an absolute duty on a master if it, in certain circumstances, to take action. Where the health of the crew or the seaworthiness of the vessel is being placed in serious jeopardy. And as a human, I also agree that being in mental distress should be given the same status as a physical injury, although I think often and sadly in practice, kind of mental illness is not accorded the same level of seriousness. But I'd have to look at the clause.
I mean, I noticed that you said during the course of your bit that you were not terribly impressed with the versions that were out there at the moment. Do you think there are some obvious changes that are ready to be made?
Did I say that? That sounds like an extreme position for me to take. I think I don't think it was specifically in relation to the no crew change clause. I mean, I'm not wildly impressed by that kind of clause being in circulation. I think there are very good reasons, very obvious reasons why changing the crew is good, both for the crew members themselves, but also for the safety of the vessel. I think more abstractly, it was that charter parties generally, and without any new clauses being introduced, simply struggled, that they're just not apt for dealing with many of the situations that COVID has given rise to, and that, you know, sounds all the way through from when we started to look at force majeure issues at the end of last February, all the way down to the minutiae of how to tender a notice of readiness validly, with simply trying to, you know, catch up with the reality and with the kind of mess it's making of previously settled contractual positions.
Yeah. Philippa, did you have a view about the crew change clause question?
I don't have a great deal to add to what Beth has said. I suppose the two things I would add are, firstly, obviously a deviation to save life is not going to be a deviation in the sense of an unapproved deviation, which will bring a carriage contract to an end, even if that is a doctrine that is still good law. Obviously, there are questions of degree there, but there are certainly arguments to be had around the position in relation to severe mental distress and mental health issues. One would hope that the result would be that, as the questioner suggested, an issue of this kind would, if in the right circumstances, not be caught by any crew change clause. I think the second thing to say is that, without wishing to sound preachy, my own view is that these crew change clauses are a menace, actually, because seafarers do have rights, and those rights are sadly often disregarded. It won't have escaped the audience's attention that the standard clauses, the approved standard clauses, such as the BIMCO crew change clause out there, are not no crew change clauses, they are crew change clauses, and they are designed to facilitate the crew change to which crews should be entitled, and simply to make sure that the financial consequences of crew change in these current difficult times are catered for in a way that is fair, and is fair to both sides of the contract. No crew change clauses, in contrast, seem to me to be an attempt by charterers to visit costs on owners, and more importantly, to visit not just financial costs, but human costs on the crew. And I rather hope that in the fullness of time, those parts of the market that have an influence are going to be able to put pressure on parties not to use those clauses.
Thank you both. I see we've got Kieran back.
Thank you very much, and thank you also to the Centre for organising this event, and for inviting the shipowner's perspective on this hugely important and depressingly still topical matter. It doesn't seem to be going away anytime soon. I'm just going to load up my PowerPoint slides here, so if you just bear with me for a second. So I was just going to go on to say that ICS, we have been heavily involved in the whole issue of crew changes from the outset. This slide here just gives a little bit of information about ICS, and I'm not going to spend any time on that. I think what I'm going to try and do today is just to explain the events that have led to the delays which both Philippa and Beth have touched upon, have addressed, because we believe obviously that those delays will lead to claims further down the track. And what I want to do is just to explain the reasons for those delays and actually what was happening at the sharp end for ship owners. The principal reason for those delays was really the impact of closing of borders and restrictions on movement that governments placed when the coronavirus started to spread. Fortunately, despite those restrictions, shipping companies and seafarers have continued to keep trade flowing, transporting all the energy, the food, the raw materials, and the other crucial goods that we all depend on for life in our 21st century. Just some statistics. These goods constitute some 11 billion tons of cargo a year, and that equates to about 1.5 tons for every person on the planet. And that's all shipped by the commercial fleet. And this slide here just demonstrates the extent of global shipping activity in any one day. And it's much more visual than I could possibly describe. Each of these dots here is a commercial ship. Now, I have to work out how to change these slides. Ship operation is, of course, a colossal operational task. It's hugely complicated. It involves a very heavy piece of machinery and all the equipment, as well as managing the cargo on board. And it requires a highly skilled and professional workforce. And that's even before considering the challenges and risks of the marine environment in which the ship seafarers work. There are close to 65,000 ships worldwide in operation, manned by, actually I've put 1.2 million seafarers on the slide. I'm told it's actually 1.7 million seafarers. And of these, 100 to 125,000 will need to undertake crew change each month. So really, it is a colossal operation. Seafarers are really the invisible heroes, bringing our food, our raw materials. They are invisible to most people who receive these goods, but nevertheless, their lives matter and they have rights. And one of the most important of these is to be repatriated at the end of their contractual service. And as I say, it's about 100 and 125,000 seafarers who complete their tours of duty. They need to be relieved in order to comply with international maritime regulations for crew health and safety, and to ensure that the ship's safety and protection of the marine environment is maintained. The crew change exercise refers to the entire process of seafarers travelling to and joining a ship in port, and seafarers on board leaving a ship in port and travelling back to their country of residence. The ability to perform crew changes in ports around the world is absolutely central to seafarers who need to earn their livelihoods, take leave to preserve their health and welfare, and it's central to ship owners for the reasons I've said, namely to make sure that their ships are safe, environmentally sound, and efficient. So what happened when the pandemic started to sweep across the globe as from January last year? The first thing we saw was countries closing their borders as part of their efforts to contain the virus and to prevent its import into their territory. It was astonishingly fast. It was really a real operation of metaphorically raising of the drawbridge. These restrictions, whilst an understandable response to the pandemic at a national level, were also applied unjustifiably and, in our view, illegally to seafarers working in the international shipping industry, such that they were unable to leave their ships at the end of their tour of duty and to be repatriated. What these measures meant to seafarers was no crew change, no shore leave, and in some cases, shockingly, no access to medical treatment, even in cases of acute medical injury and illness. And what did it mean in practice? between the 1st of March and August 2020, only 25% of necessary crew changes actually took place. By August 2020, 500,000 seafarers had been affected. About 150,000 seafarers still required immediate repatriation, and 250,000 were serving on extended crew contracts who were overdue to return home. And this is in addition to those seafarers awaiting ashore to actually start work and earn their livelihood. So these are the serious humanitarian and crew welfare concerns that were really occupying most of our resources and time. It raises issues of regulatory compliance, and it raised concerns that there was an increasing risk that fatigue would lead to serious maritime accidents. As well as restrictions placed on the movement of seafarers by national and local authorities, there was also the problem of a suspension of the majority of flights between major crew change ports and the principal labour supply countries, especially those in Asia, where the majority of the world's seafarers reside. It's hard to exaggerate the impact on international ship operations. As a result of the pandemic, the economic fortunes of large numbers of individual shipping companies have been greatly affected. And that's been due to the severe contraction of demand for their services and dramatic levels of freight volatility. The cruise ship industry in particular, with virtually all operations suspended during the initial stage of the crisis, was really the first to feel the impact of the coronavirus. For us, for ICS, throughout this crisis, the priority, and for our member national associations, has been to work with governments to ensure the safety of crew and ensure the maintenance of safe and efficient supply chains. And so we established quite early an industry crew change task force that was established in April 2020 as we started to receive questions on a daily, hourly basis as to the different regulations, the different restrictions which were being imposed by ports. And ships were either being denied entry, or in some cases, in most cases, ships were allowed access to the ports in order to discharge their cargo or take the cargo, but the seafarers, the human element, were just denied entry at all. We pursued a strategy with several elements. In particular, what we sought to do was to ensure that the need to identify seafarers as key workers and the necessity that maritime trade should continue to flow would be identified as critical priorities by governments around the world. And what we did first is lobbied for affirmation of these priorities at a series of emergency G20 leader summits on COVID-19, which were held in March and April 2020. But supportive words from governments still needed to be followed by action, especially with respect to facilitating ships' crew changes. And to help countries to agree for these to take place, we, together with our industry partners, our other associations, we worked to develop practical guidelines. And it was in close liaison with relevant global bodies, including the industry's global regulator, the IMO, and the International Labour Organization, ILO. And we worked very closely with the Global Union for Seafarers, the International Transport Workers Federation, ITF. And the first practical outcome of this liaison and work was a development in May 2020 with the IMO and the World Health Organization of a comprehensive framework of protocols for conducting crew changes safely. This was circulated by the IMO Secretary General to governments worldwide in May 2020 with a strong recommendation that they should be implemented nationally. These protocols have since been updated to give additional emphasis to the importance of compliance with testing and quarantine requirements. And they were designed to provide comprehensive guidance to governments to enable them to facilitate crew changes safely and to comply with their obligations under the MLC, the Maritime Labour Convention 2006. They provided a step-by-step guide from the seafarer leaving the ship, going through the port area, travelling through the country, boarding a plane, and then steps on the other side when he actually or she arrived at their country of residence. And in return for adherence to these protocols and recognising the key worker status of seafarers as advocated by IMO, governments were requested to facilitate crew changes, notwithstanding any restrictions that might apply to other international travellers. And this was really to give concrete meaning to the word key worker. That was absolutely essential. And of course, we saw key worker designations at a domestic level, but we did not see that the same right was accorded to these international seafarers. The protocols were followed by other guidelines and recommendations throughout the summer months last year. In parallel to that, we were pursuing political and legal avenues as to how we could address this. The protocols gained some traction, but many national authorities continue to insist on applying quarantine procedures to seafarers, which we've heard about just now, and other requirements such as ships having to remain at berth or anchor until those seafarers being repatriated have actually departed on their flights, which, given the shortage of flights available, continue to be highly problematic. The crisis continued, and especially as the various countries experienced new waves. I mean, there were various cycles going on at any one time. So whilst one country managed to bring the virus under some degree of control, other ports where the same ship was calling at was at a different stage of that cycle, and so there were restrictions there as well. And the fundamental difficulty remained that regardless of the obligations of governments under existing international maritime regulations, which have been adopted by IMO member states and ILO, instructions from national political leaders and their local health authorities were given precedence over those obligations. And that was the real problem. There was a real lack of cooperation or coordination between the different ministries, one dealing with transport and the other dealing with health. There was just a lack of coordination as to what the consequences would be as far as international regulations and compliance with that was concerned. So that was the background. Maybe if I can just give some information on what these legal obligations are. I think I might have missed some slides. We've got the Maritime Labour Convention 2006 as amended. This is widely known as a Seafarers' Bill of Rights. It was adopted in 2006, and there have been a number of amendments since then, really to address various issues as they've come up. It sets out a comprehensive code for seafarers' rights to decent working conditions, and it covers almost every aspect of work and life on board. It recognises the unique nature of the international shipping industry, where seafarers from labour supply countries serve on board ships registered in other countries for many months at a time, away from their families, and calling at ports in countries around the world, and therefore subject to different jurisdictions. It recognises also that the nature of their trade and their profession places them in a very vulnerable position, and therefore it provides them with express protections. These protections, is set out in this slide, include the general obligation on all member states to cooperate with each other to ensure effective compliance with the convention. That, as it turns out, is a key provision that we have used to good effect, and I'll come on to that in a minute. And it provides specific obligations in their various capabilities as flag, port, and labour supply state to ensure that seafarers have access to medical treatment from ashore, and that they have access or they have the right to shore leave, and that they can be repatriated in accordance with the crew contract. The seafarers' health and welfare is entirely reliant on member states meeting these obligations. So it's not just a flag state. MLC has been ratified by 97 countries. So it is fairly widely ratified by most states to which ships will be calling. Now, a convention that seeks to protect the rights of seafarers working in an international industry requires member states to engage actively and constructively with other member states and industries to ensure compliance with their obligations. And that's where I think the duty to cooperate, the obligation to cooperate, really has some meaning in this context. In the present global pandemic, it would mean coordination between national governments to ensure that borders remain open for the seafarers to disembark from the ship, that they can travel from the ship through the country to the airport. It would entail cooperation and coordination with other member states and industries to ensure the availability of international air transport to allow them to complete their journey home unimpeded and without delay. And it's that international cooperation which was missing. Actually, it was national cooperation as well, as I've mentioned already, but it was the international cooperation which really saw the whole system falling down for seafarers. So in the light of the continuing restrictions and the unfolding humanitarian crisis for seafarers, both on board and for those ashore unable to work, one very important action that ICS took in coordination with our social partner at the ILO, the global union ITF, was a submission of formal comments to the ILO, to its committee of experts, which is comprised of MLC member state representatives. And what we said was that we considered that there was a significant failure of member states during the pandemic of their obligations under the MLC, and specifically the failure to comply with the obligations to allow seafarers to disembark and repatriate, and also the access to medical treatment was really, really shocking. And so we wanted to highlight that. And we urged the committee to consider the comments and to really urge compliance and uniform enforcement of the convention. The submissions actually led to a landmark ILO ruling in December, on the 12th of December, that governments have collectively failed to protect the minimum standards for the protection of seafarers as set out in the MLC, and it urged greater international cooperation by states to ensure that seafarers are protected. And actually there does seem to be some proposals by states now to try and give effect to that. We've seen a proposal from France recently, but we're not quite sure that actually it will achieve what it might want to achieve. But I think the positive thing is that actually the decision of or the ruling has actually encouraged states to start looking at proposals for addressing the issues that we've highlighted. In addition to that, and actually even prior to the ILO's ruling, the UN General Assembly adopted a resolution calling for all countries around the world to designate seafarers as key workers. And again, we are now trying to bring that into practice with trying to implement that, or trying to encourage states to implement that. They're all important achievements, but clearly much more needs to be done to bring those into concrete actions. On the contractual side, we have heard Philippa and Beth just mentioning what the issues are from the contracts, and touched upon the provisions dealing with deviation. I think if I can just spend a couple of seconds on this, there were implications from the pre-change restrictions under shipping contracts, such as charter parties and contracts for carriage. The limited number of ports open meant that actually, in order to comply with their flag state regulations and in turn the MLC regulations, ships really did have to deviate quite a lengthy deviation if they were to find a port where the seafarers could be disembarked and repatriated. It raised questions over whether the contracts contained provisions to allow ship owners to do that legally. And we looked at precisely the questions that have been mentioned here. There are existing deviation clauses, but whether they would encompass the circumstances that we are facing was questionable. And there was also issues as to whether the insurance cover would be in place, because I think you would have questions as to whether that deviation was reasonable. And whilst you might succeed at the end of the day in view of the circumstances, it's not an exercise that you really want to do if in fact you can have provisions that are quite clear on the point. So we did get together with the International Group of P&I clubs to try and draft a model clause. This work was subsequently passed to BIMCO to take forward, and their BIMCO's COVID-19 crew change clause, time charter parties, was published in June 2020. I think more recently on the role of charterers generally, we believe that as partners to the common maritime adventure, they too have obligations and responsibilities to ensure that it's actually completed safely and that the welfare of the crew is protected. And somewhat to our dismay, we are increasingly seeing cases where individual charterers have introduced clauses that actively seek to disallow deviation for the purpose of making crew changes, or which seek to exclude crew changes completely during the currency of a charter party. There are also reports that some charterers have otherwise sought to reallocate the risk of crew changes, for instance, by demanding blanket letters of indemnity to be signed before crew changes take place, or more discreetly, perhaps, refusing to charter ships that had recently conducted crew changes in fear that COVID-19 might be an issue for the seafarers on board. We, of course, condemn these clauses, and we have actually raised this at the recent meeting of the IMO Legal Committee in December 2020. The statement that we made was widely supported by member state delegations and other industry partners. The meeting was followed in December 2020 with a statement, with a letter from the IMO Secretary General condemning the use of such clauses and calling for charterers not to request their inclusion as a matter of safety and corporate social responsibility. It also called upon ship owners to reject such clauses when they were proposed. Now, the support from the IMO and member states is welcome, and we are now considering how we can follow this up at the regulatory level at IMO or with individual states. But we do acknowledge that states have limited power to address clauses which form part of a private contract of carriage between an owner and a charterer, and that the decision of a seafarer when faced with such a clause will be dictated, no doubt, by the economics of the current market. So we're a little uncertain as to what we can do, but I think publicising this is actually very important as well. So that's a quick round, well, maybe not so quick, that's a roundup of events over the past year. And where are we now? We've got to the end of December with statements, with resolutions of the UN and decisions of the ILO. As we start 2021, the global crew change crisis is still an ongoing priority issue. We remain active at relevant global bodies to promote adherence to the framework of protocols to facilitate safe crew changes. I think also in January 2021, and what we're seeing nationally and globally, is that the entire world is having to address increasing infection rates, which has been complicated by the new variants which are coming forward. And it's leading again to draconian travel restrictions by national health authorities, with countries again closing borders, and the possibility that international flights might again be reduced. The emergence of vaccines, which is seen increasingly as the only realistic way out of this crisis, is now high on our agenda, and particularly to ensure that governments put seafarers and frontline maritime shore workers at the head of the queue for vaccines, And again, this will require seafarers to be designated as key workers. And really that's to avoid a repeat of the 2020 crew change crisis. So to this end, there has been actually just yesterday, I think there was a public launch of a broad coalition of industry associations, individual ship owning companies, representatives from the wider supply chain, including commodity houses and charterers, to take action to support seafarers immediately. It's called the Neptune Protocol. It's been widely trailed in the press and the news yesterday, so I think many of you may have come across it. It's identified key issues that need to be addressed. They include recognising seafarers as key workers and to treat them accordingly by giving them early access to COVID-19 vaccines, to implement high quality health protocols, to increase collaboration between ship operators and charterers and the wider supply chain to facilitate crew changes, and ensure airline activity, really airline connectivity to ensure that travel is available for the seafarers. And I think actually, the most important thing here is that really we need to take action to deliver on our shared responsibilities as far as crew are concerned. And this document just sets out exactly what needs to be done in that respect. So I think that's where we are at the moment, and I will conclude there.
Thank you very much indeed, Kieran. We've obviously run a little bit over time, but I think we'll just maybe try to take one or two questions before we shut up shop for the evening. And obviously with the question of the no crew change clauses and the issues that Kieran has been talking about very much in mind, one of the issues which has cropped up in the Q&A section is the scope for arguments in relation to public policy when one is considering no crew change clauses, and that bridge between the public policy arguments and the contractual arguments. Do you think there's any scope for attacking clauses that way? Philippa?
Attacking a contractual clause on the grounds of it being contrary to public policy is of course always very difficult. And there must be questions around illegality as well, I guess, although the state of the law on illegality is, to say the least, an interesting one. I can certainly see there being scope for those kind of arguments in the future. Whether they'd ultimately fly
Yes.
depends on all sorts of things. It may depend on where we are actually in terms of the regulatory environment. And I suspect that in the long run, sadly, that may be a better way of addressing these issues than through trying to do them in the ordinary contractual framework, if I can put it that way.
And the argument about illegality and public policy gets so tangled up in how particular issues of public policy are dealt with in different fora, and the domestic view compared to the view elsewhere. And I believe there have been different approaches to exactly how one brings the Maritime Labour Convention into domestic regulations in different jurisdictions, haven't there?
That is, I'm sure that is right. I suspect that is one where Kieran is best placed to comment.
Yes. I don't know, have you given that any thought, Kieran?
I don't think that the Maritime Labour Convention would actually encompass that sort of issue, that sort of question. I think actually, just thinking about this, the clauses which we have seen seeking to have no crew changes during the currency of a charter party, they are receding. Actually, what we're seeing is inquiries made of charterers during the negotiation process, actually trying to find out what the status of the ship is as far as crew changes is concerned. And if those negotiations and those inquiries reveal that there will be a crew change or there has been a crew change, that will actually discourage a charterer, or that could discourage a charterer from going with that particular ship, fixing that ship. So I think that is where that's probably going to be outside the bounds of any oversight by the courts or by regulations or by legislation. I think that's just going to go by, you know, it will just fall out of the regulatory legislative picture.
And I think we've had one question about the question of what is going to be happening if you've got a situation where the crew go somewhere towards the end of a charter, which is a high-risk place, and contract COVID, which then only manifests after the charter has completed. How is that going to end up being within the indemnity in the previous charter, or is that going to be on the owner? Interesting.
Interesting and untested. I think that's going to be one for maybe for you.
Yes, I can see that is one that has obviously happened to somebody. And likewise, any views about situations where, for example, you have a loss of time because somebody has to leave port to change crew, but thereby causing delay. But you would have been, for example, sitting in a large queue outside the port in any event.
Well, that's going to depend on the clause, isn't it? I think.
Is.
Because you say that that's caused delay, but on one view, in fact, it hasn't caused any delay because the delay would have been caused anyway. So it might depend on whether you were dealing with a time thereby lost clause.
Yes,
and wider in its operation.
And I think there are obviously in a different context. It's not unheard of for a vessel to depart a lengthy queue to go and do something else and then try and rejoin, and placing the risk of all of that time accruing down the line. So I think that has been dealt with, albeit in a different context. I think the answer is somewhere along the lines of that's an authorised deviation, so technically a breach of the charter. You cannot just depart and then rejoin the queue. But then we may have to look at the causation aspect that Philippa just touched on to see whether that would still hold in the present context.
Well, I think we are now at 6:30 and we have overrun by a little period of time. So I think it may be time to draw to a close. Can I just thank all of the panel for their really interesting and invaluable presentations this evening. It has been an education and slightly concerning, the scope of the number of arguments which may be coming in my direction and in the direction of the maritime arbitrators in the not too distant future. So thank you all very much. And could I also, of course, thank the London Shipping Law Centre again for organising this event, and to Essex Court and Lucy in particular for offering the technical support. Thank you all very much, and I wish everybody an extremely pleasant evening.
Thank you.
Thank you.